Assalamualaikum warahmatullahi wabarakatuh. We are from TLB 11. So today we will discuss about HONAN Plantation Sdn Berhad and Kerajaan Negeri Johor and another. This case is under the subject of the land acquisition. So this is an appeal case. Okay, the fact of the case is the appellant, which is HONAN Plantation Sdn Berhad, was the registered proprietor of a piece of land, and the gist of the appellant's complaint was that the property was acquired contrary to law, in the sense that the acquisition was ultra-vires and unreasonable. And after service of the writ and statement of claim, applications were taken up by the respondent to strike out the action on the ground that it disclosed no reasonable cause of action. So the issue here is whether an acquisition under the Land Acquisition Act 1960 was capable of challenge, and if so, on what ground. So it was held by Gopal Sriram, the judge of Court of Appeal. First, the principle governing an application made under Ordinance 18, Rule 19 is that pleadings ought not to be struck out, save in plain and obvious cases. And the second one is, an acquisition made under the provisions of the Act cannot be challenged unless a plaintiff establishes that the acquiring authority had misconstrued its powers or had acted in bad faith or with gross unreasonableness. So the statement of claim in the present case includes a challenge which falls within grounds of challenge as formulated in established cases.
My name is Siti Nurmutia binti Harun. I'm from TLV 11. Now I will continue with the judgment of the HONAN Plantations case. Okay. First of all, this case was decided by our Honorable Judge Gopal Sriram, Judge of the Court of Appeal. Okay. He delivered an oral judgment of the court. He said that the appellant before us, which is the plaintiff in the court below, was the registered proprietor of approximately 996 hectares of land situated in the state of Johor. It filed their proceeding in the High Court of Johor in order to challenge the decision by the first defendant, which is the state government of Johor, in order to acquire the land. Returning to the facts of the case, the plaintiff in its statement of claim, apart from joining the government of Johor and the land administrator, cited Prowling Sdn Berhad as the third defendant. The gist of the appellant's complaint is that the subject property was acquired contrary to the law, in the sense that the acquisition was ultra-vires or vitiated on anismic grounds, which is we refer to the anismic limited and Foreign Compensation Commission case. In this case, the land judge, who heard both sets of applications, granted them and struck out the plaintiff's statement of claim. The appellant has now filed two appeals, and as I have said in the first appeal, it is the Johor government and the land administrator who are the respondents. The application to strike out in the first appeal was based on the Order 18, Rule 19, Subsection 1, 1A of the Rules of the High Court, 1980. In the second appeal, the affidavits were also filed, but as an events transpired, they were not used. Counsel before us have therefore proceeded on the ground that both appeals are grounded and are to be treated as having been made under Order 18, Rule 19, Subsection 1A. All these principles governing an application made under Order 18 Rule 19(1)(a) are well settled and have been stated by our courts on many occasions. Under the rule, for example, Rule 25, Rule 4, it had to appear on the facts of the plaintiff pleadings that the action could not succeed or was objectionable for some other reason. No evidence could be filed, but as the procedure was of a summary nature, the party was not to be deprived of his right to have his case tried by proper trial unless the matter was clear. In the essence, the principle is that the pleadings ought not to be struck out save in plain and obvious cases. The land judge in the present case stated that principle applicable to an Order 18 Rule 19 application with accuracy. The only complaint before us by the applicant is that he misapplied those principles to the facts of the instant appeal. At the heart of the matter lies the question whether an acquisition under the Land Acquisitions 1960 is capable of challenge, and if so, on what grounds. That question has already received judicial treatment in cases decided by the highest court of this country, such as in the cases of Sayoma, Abdurrahman Taha Al-Sagaf, and the government of the state of Johor. This case has same facts of the case, has same essence of the case with the current case, which is HONAN Plantations. An acquisition made under the provision of the Act cannot be challenged unless a plaintiff establishes that the acquiring authority had misconstrued its powers or they had acted in bad faith or with gross unreasonableness. The limit of the challenge is occasioned by the wording of Section 8, Subsection 3 of the Land Acquisition Act, which reads, A declaration informally shall be conclusive evidence that all scheduled land referred to therein is needed for the purpose of specified therein. Therefore, in the conclusion, the declaration informally is conclusive as to the purpose for which the scheduled lands are required, which will mean that the Parliament has decided that the state authority is the best judge to determine what amounts to a purpose which is beneficial to our economic development. That's all from us. Thank you.